This is the first video in my series on the civil procedure rules. So this is an introduction on how you can understand the civil procedure rules, what they are and why they're important. For the full series, you can go to BlackBeltBarrister.com and subscribe there to the full course, which not only includes this series on the civil procedure rules, but all of the skills of advocacy that a barrister learns at bar school so that you can learn them and use them throughout your life, whether that's for an interview or social interactions, business interactions, and so on. So for this video, I'm going to give you an overview of what the civil procedure rules are, why they're important, and how you might be able to use them in any civil claim. Or if you are a student, so that you can better understand how the civil procedure rules work. So first of all, it's important to know that the civil procedure rules will apply to all civil claims, including small claims, although there are some rules such as costs that specifically relate to small claims, but we will be covering that in specific videos dealing with small claims. So we're navigating the civil procedure rules as a block of rules, but without the commentary text, which I'll explain in a moment. I like to use Westlaw's website, which sets out the civil procedure rules on a very basic website, which allows you to read what they are. It's important to remember they will not necessarily be entirely up to date, and it is important to check the official government websites for civil procedure rules to make sure they are up to date. First of all, you should know that there are 89 parts to these civil procedure rules, plus what we call practice directions. Practice directions you can think of as a way to help you understand what the rules are and how those rules apply. The parts within the civil procedure rules go through everything from what the court's main objective is, through applying and interpreting these rules, the court's powers when it comes to cases, what forms are required, what documents are required, service of those documents, how to start proceedings, and so on. So let's take a look at some of these sections so we can get an idea as to how these rules work. Looking first of all at Part 1 of the civil procedure rules, the overriding objective. The rules are set out in very simple language, telling you exactly what these rules are supposed to be. Part 1.1 is the overriding objective. This sets out what the court's primary objective is, and as it suggests, it's an overriding objective. It is the objective that the court is seeking to achieve at every stage of every case. Part 1.1 reads, these rules are a new procedural code with the overriding objective enabling the court to deal with cases justly and at a proportionate costs. Secondly, dealing with cases justly and at proportionate cost so far as is practicable, ensuring that parties are on an equal footing and can participate fully in proceedings, that the parties and witnesses can give their best evidence, saving expense, dealing with the case in a way which is proportionate, firstly in respect of the amount of money involved, the importance of the case, the complexity of the issues, the financial position of each party, ensuring that it is dealt with expeditiously and fairly, allotting the appropriate share of the court's resources, that's for example time, and enforcing compliance with the rules, practice directions, and orders. So breaking that down yet further, the court's overriding objective, its primary objective, if you will, is to ensure that all cases are dealt with fairly, with an appropriate amount of court time, taking into account each party's individual position, financial position, the complexity of the issues in the case, and the amount of money, all the important issues involved in the case. Now, whilst any individual might think that a £200 or £300 claim is obviously paramount importance to them at that time, the court is naturally going to look to cases with hundreds of thousands of pounds in a slightly different way than those that are just a few £100s. Hence, there is a section on small claims, which we will get back to later in the course, which deals with the situation where there is a monetary claim not more than £10,000. This brings us on to another area of the civil procedure rules, which deals with tracks. A track is simply a way that the court indicates which rules are going to apply to that particular claim, timeframes that will apply, and how the court will deal with the claim. So for small claims that you will have heard of, which is in a monetary sense not more than £10,000, it will be on the small claims track. Many people mistake this to be the small claims court. That's not quite accurate, although if you think of it as the small claims court, it's not detrimental. It just means that it is a small claims track which is heard at the county court. So small claims are heard at the county court. There is no separate court just for small claims. The next important section to talk about for this introductory and overview video would be Part 7 of the Civil Procedure Rules. Part 8 is an alternative to Part 7, which I'll come back to. But Part 7 is essentially how you start proceedings, how you start a claim. So if we take a look at Part 7, it tells you in sequential order where you will start proceedings, how to start proceedings, the fact that you can use one claim form to start 2 or more claims. This might be the situation where you have more than one claim against one person, but they might be linked in time and fact, and so it is expeditious to use one claim form and bring one claim against that party because they can all be dealt with at the same time. Likewise, if you have a claim arising out of the same set of facts but against 2 separate parties, you can use one claim form, you can start one claim, and you can include both parties in that claim because essentially the court can hear all of the facts, all of the evidence, and decide on all of the issues at the same time. Remembering the court's overriding objective, that is to allot an appropriate amount of time, resources, and etc. in respect of each case and each claim, so that if 2 claims can be heard together, that is going to be much more expeditious and effective to go towards the overriding objective. Within Part 7, a very important element is the particulars of claim. This sets out how you are going to write up your claim, and the particulars of claim just means the details of your claim. It isn't evidence yet. This is a big mistake that lots of people make when looking at the civil procedure rules and going through the court process, because they think that once they've done the particulars of claim and they've told the court everything they want the court to know, that is it until you get to court. But that is not quite the same, because the particulars of claim is not the evidence that you will rely on. The particulars of claim essentially sets out the facts upon which you will rely to bring and hopefully succeed in your claim against another party. So the particulars of claim is just that. It is a sequential, factual list of everything that happened, and most importantly, detailing what it is that gives rise to a claim against the other party or parties, and how much that is for, or if it's not for money, what it is that you are seeking. Perhaps you are asking the court to make an order to prevent someone from doing something. This would be a prohibitory injunction. Not that you necessarily need to use those words, but you can put in your claim that you would like them to stop doing this. And if you're a litigant in person, so long as the court can understand what it is that you are asking the court to order, that can be part of your claim. Part 7 also deals with service of the claim form, which is extremely important because if it is not served correctly, then any judgment that arises from it, perhaps say for default judgment, may be set aside or in some circumstances must be set aside. Coming back to the top menu, again, as I said, Part 8 is an alternative procedure for claims. I will come back to this throughout the course, but in short, it means where there is no substantial dispute of facts within the claim. In other words, 2 parties don't necessarily disagree with what happened, but they might disagree as to what the remedy or the next step forward might be. That is when Part 8 might be used, and there are indeed some situations where Part 8 cannot be used. But again, I will come back to that during the course. Part 9 of the Civil Procedure Rules is responding to the particulars of claim. In other words, this is going to be how you respond when someone brings a claim against you. This might be just to admit the claim or admit part of it, or you may not admit any of it and you might file a defense for it. And Part 9 guides you on how to respond to the claim. This is not to be confused with the substantive defense itself, which is dealt with in Part 15, which goes into detail on a defense and reply. Part 15 details how you provide a defense to a claim and what format that should take, whereas the reply is coming back from the claimant, which is a response effectively to your defense. And it should be limited to issues that arise out of that defense, but again, that will come up during this course. As to the contents of each of these, that being the claim form, the particulars of claim, and the defense, and the reply, and so on, these are dealt with in Part 16, and there's a lot of detail here as to how to write those up. And if there is any ambiguity in any part of those rules, this is where the practice direction comes in, because this will help you to understand what the rules mean and how they are applied. So as you can imagine, with 89 separate parts of the Civil Procedure Rules, this will take quite some time to go through each and every section, but this is what you will get on part of the course over at BlackBeltBarrister.com. These rules are extremely important because if you fall foul of any of these rules, you might get either part of one of your statements of case, whether that's a particulars of claim, a defense, or so on, struck out, meaning it no longer exists unless you rectified the problem. They're also important because if you breach any of these rules or practice directions or any of the court's orders, you may get costs awarded against you, and this in some circumstances might even apply on the small claims track, where ordinarily you cannot claim for your legal fees, but there are some provisions if the litigation has been conducted badly and their client deserves some of their costs to be repaid. So if you've never heard of the civil procedure rules before, I hope this was a useful, if brief, overview. And if you do want to learn very much more about it, either for your own claim or you are a law student and you want to know more about these rules, then please head over to BlackBeltBarrister.com, check out the subscription there, and each of these sections I will be covering in a great amount of detail. And if you are a law student but you are yet unsure as to whether you want to follow the path of becoming a barrister or a solicitor, then I can highly recommend that you subscribe to this course, because this is the backbone of the civil litigation module at Bar School, which has the notoriously difficult exams to pass at the very end, which are single best choice answers, meaning that more than one answer might be correct, but there is one of them that is slightly better than the other, and you will only know which it is if you are intimately familiar with these rules. So thank you for watching this brief overview of the civil procedure rules. Check out BlackBeltBarrister.com, and remember, stay humble and subscribe.